Truly, there's not enough legal analysis of the latest indictments coming out of Georgia. They're that unprecedented. They're that remarkable. Frankly, they're that enraging. So joining us now to give us his take is Jordan Sekulow. He, of course, the host of Sekulow right here on the Salem News Channel, and also the executive director of the American Center for Law and Justice. Thank you so much for joining us again, Jordan.
Thanks for having me, Larry.
So on the face of it, a big chunk of this indictment appears to be President Trump getting legal advice from his lawyers about the validity of the election, specifically in Fulton County, Georgia. And he's taking that advice and acting on it, right? I mean,
right.
Now again, the advice could have been wrong, the analysis could have been wrong, but they're criminalizing him, his actions, by actually acting on his lawyer's advice, right?
Yeah, that's right. It's actually what enrages us the most. One thing at the ACLJ, as a group of attorneys that are engaged in an adversarial process on a regular basis where we believe a law or a piece of the Constitution should be interpreted this way, and either the government or another party we are against in court believes that it should be interpreted a different way. And neither one of us are criminals for going to court to fight for that. And we're not criminals to fight for those views or to offer that advice to our clients. And in this case, when you're the president of the United States, you have a number of advisors giving you lots of options saying, and then you ultimately choose. There may be advisors saying, I don't think this is right. Advisors saying, I do think this is right. Yeah. And you choose one to go with. You go into court, you fight your battles. That's what happened here. We actually did one of the election cases in Pennsylvania. We set some ballots. We were able to set some ballots aside that weren't dated. There was a win there. I mean, so election challenges aren't RICO and they aren't criminal. It's normal in our process to have election day lawsuits filed, post-election lawsuits filed. But what is most, I think, dangerous here, Larry, as someone who also served on President Trump's legal team for the special counsel investigation and the first impeachment, is the attack on lawyers. Yeah. We are, in a sense, the bulletproof vest in between the legal system, the state, if you will, the prosecution, and our clients. Yeah. And when you can no longer be in that position and you have to fear becoming a defendant yourself by representing your client, we are no longer operating in the U.S. justice system that was created to have a equal justice under law.
Yeah, I think people like to throw this term around a lot, but it certainly applies here. A chilling effect, 100% chilling effect. All right, so based on my understanding of Georgia law, though, the defense of, listen, I was just stating my opinion about how things were going with the election. I disagreed with the outcome, and therefore I was stating that opinion. Apparently, there is language in Georgia state law that says, and I'm quoting now, you can't make a false, fictitious, or fraudulent statement or representation in any matter within the jurisdiction of any department or agency of state government. In other words, because President Trump allegedly maintained his belief about the outcome of the election to the Secretary of State, that was a criminal act. Does that hold water?
No, I don't think. I think this is, again, it's speech. The idea is that he believed what he believes it today. And well, again, he says it on the campaign trail over and over and over again. And people have said, even advised, say, hey, maybe stop talking about it. He doesn't. I mean, it's clearly that President Trump believes that the last election was stolen. Whether you believe that or not doesn't matter. He believes it. He did not think he was fraudulently going in there and lying by pursuing that belief and trying to correct a wrong that he believed in and that his team of attorneys were advising him on.
Yeah.
How to correct that wrong. It's not like he tried to do it himself. He went to a group of experts, law professors, well-known attorneys in Georgia, criminal defense attorneys in Georgia, election law attorneys in Georgia, and said, what could be done here? Let's try. It's okay in the U.S. legal system, or groups like the ACLJ wouldn't exist, to try novel, new approaches under the law. It's something you do when you zealously represent your client. And like you said, Larry, when it's a chilling effect, this time not so much just on speech. I would say the D.C. case, that's a chilling effect on speech right there. This Georgia case is a chilling effect on getting legal representation. We already know that President Trump has a tough time with a lot of these big law firms not wanting to represent him. So people are having to leave their jobs at big firms to represent him, and then they end up as criminal defendants. So what do you think their ultimate goal here is? It's not to put people behind bars. It's to, again, it's to make everyone think twice before associating with President Trump to damage him politically.
All right. Now, some of the analysts out there who are a little bit more sympathetic to this indictment, or these indictments, I should say,
Sure.
they'll say, listen, this goes well beyond speech. What President Trump did wasn't just voice his opinion, he was taking actions. They point to the alternate slate of electors. They point to various other actions that there's alleged in the indictment. How do you respond to that?
You know, it's interesting. Alternate slate of electors and the Electoral Count Act has gone back and forth in court over the years. JFK actually had a proposed alternate set of electors once out of Hawaii. And I mean, there was no criminal charges filed there. It was, again, there was questions about the election, the results coming in late. So they had assembled that team. If you look at the charges, I would say that those are probably the most unique in this, Larry. I'd say if there were people who did what this alleges, I'm not sure they did, but if they did what they alleges, then they may be in some trouble. If you went and said that you were part of a actual government agency, as they allege, and you could, put your stamp as a formal stamp as the state of Georgia, that might again propose some issues.
That would be fraud. That would be fraud and misrepresentation.
At this point, that's what the prosecution is alleging. And we haven't heard the defense yet to that. And I think that's going to be very important, and it's going to be a very long time from now.
There are some out there who are looking at this and saying, on a political basis, saying they welcome it on behalf of President Trump because he always does better in the polls when he gets indicted, and we're seeing that play out. But also because now President Trump can actually make good on his allegations that he's got the power of discovery. He has to be able to present a robust defense, and now this is his chance to prove his case about the 2020 election. Is that the appropriate legal strategy here, to actually relitigate the 2020 election? Or well, what, you're the counselor here, what do you think?
I think you absolutely use discovery to get as much information as possible that was withheld from you in the last election. You can do that with your attorneys without relitigating it necessarily on the campaign trail. On the campaign trail, you can talk about the issues facing the country right now, what people are really concerned about, the economy, our standing internationally, China, immigration, our border, the drug crisis in America, the list goes on, inflation, etc. But your attorneys then can use this opportunity to have a power that they have never had before, and that is full discovery. Because if you're alleging it was a lie, then they get to go back and say, well, give us the information that proves it's a lie.
Yeah. Because
we're going to ask for this information, and you really have definitive proof of A or B or C. So that's why this is, I think, of all the cases, I can go through. New York is a waste of a case. D.C. is a free speech case. The case out of Florida is a complicated documents case, so it takes time because it involves classified documents and an untested constitutional issue about how the president can declassify and classify documents. This is the most complicated. There's 19 total defendants here, 41 different charges. This is going to go on for a while, unfortunately. And in groups like the ACLJ, we're actually looking at how we can assist some of these people who have been charged. And we're looking at setting up legal defense funds and other avenues like that. We're just in that starting process now.
Yeah, but this is the case that has that tangible possibility of seeing the evidence about that election. And it's funny.
It is.
The vast majority, if not all of the cases after Election Day were dismissed because we were told President Trump didn't have standing. Well, he certainly has standing here. And it'll be fascinating to watch it transpire. Jordan Sekulow, we'll be calling on you to explain it to us as it does transpire. Thank you, sir.
Thank you, Larry.
There is more to come. It's Salem News Channel. You're watching O'Connor Tonight.